Hello, my name is Beth King-Smith and I'm here today with my colleague Caroline Cowley. We are part of the Disputed Wills Trust and Estates team. We're here today to have a chat about will challenges.
If people want to challenge a will, there are various grounds on which they can challenge a will. First one is that it hasn't been executed properly, which means that it hasn't been signed and witnessed correctly. Alternatively, you can challenge a will on the basis that the person making the will, the testator, lacked the capacity to do so. You can also say that they potentially had capacity, but they didn't know and approve what was in the will. So they didn't know the terms of the will as drafted. And the final way of challenging the validity of a will is by saying that it was procured by undue influence. This is saying that there's no other explanation to the terms of the will as they were drafted other than somebody made them do that.
Great, thank you, Caroline. So if you are concerned that somebody you care about has died and you think that there is a problem with the will, perhaps somebody took them to a solicitor's to obtain a will which they didn't really realise that they were doing, or perhaps somebody presented a document for them to sign with it and they were ill or on medication or had got dementia, then that's certainly something that we can help with, and we would be very happy to help you.
And what would be, Beth, the first thing that you would advise your client to do when concerned about the validity of a will?
I think the absolute first thing you should do is contact the executor if you know who the executor is. If you don't know who the executor is, then certainly taking early legal advice, because it may be appropriate in your circumstances to try to enter what's called a caveat against the will. That's basically a form to prevent the administration of the estate going through, and that gives you time then to investigate further.